video is being shown to you under Section 107 of the Copyright Act of 1976. Allowances is made for fair use for purposes such as criticism, comment, news reporting, education, and research. Fair use is permitted by copyright statute that might otherwise be infringing. Smash that like button. Let's go. What's up? What's up? What's up, Survivor Nation? It's your girl, Survivor Speaks, and I'm here with a video. So today's video is about YNW Melly, who is legally named Jamel Demons. So this is the first of two hearings that he had. And so we're going to go take a look at that. But just to let you know, I'm just going to show YNW Melly walking into the courtroom, and then I'll be skipping past all of the motions that the new judge will be reading. So YNW Melly has been incarcerated for 6 years. He did have a trial. It ended in a mistrial. They denied his bail. Since then, they have isolated him. They have taken his phone privileges away from him. And one of the biggest things that's going on right now is that one of his attorneys allegedly is being investigated by the prosecution.
Oh shit! Oh shit! Oh shit!
But
wait! There's more!
They did not have the decency to tell the defense team that she was being investigated, and they continue on. But good old trusting Apple advised them that the attorney's records was subpoenaed. And that's how we found out about the daggone investigation. So the prosecution just never told them, just letting them go through the motions of moving forward, while in the background they were doing this investigation on, regarding one of their attorneys. Now, if that's not playing dirty, I don't know what is. I'm somebody that looks at the law from the side of the law, not based on what everyone is saying, everybody else is saying, and not based on the person that's on trial's popularity. I don't have a dog in the fight when it comes to YNW Melly. Don't know him. He's not paying me. Don't know about anybody in his family. They're not paying me. I don't know the prosecution. I don't know the judge. I don't know anything. I am a virtual juror. And I am just sitting back and looking at things the way, and learning things the way everyone else is. And I'm going to give my daggone opinion when I feel like it. Okay? And I just think that this is a tactic, a dirty tactic that is state. I think it's a dirty tactic to use. If, for the people in the back, if YNW Melly is guilty, he may just walk because of this. Let me also say this for the people in the back. I'm basically looking at what I'm looking from a legal standpoint. I am not a lawyer. I do watch a lot of true crime. That's why I started putting content on my channel, because I was spending all of my time watching trials, watching interrogations. It's just intriguing to me. I worked in law enforcement as a correction officer for 7.5 years, so I know a little bit about what I'm talking about. But every now and again, I say every now and again, every now and again, you know, I have to, you know, consult an attorney. What does this mean? I don't. Can you tell me? So I'll just go watch one of the many attorneys' channels on YouTube, and they're reporting on this stuff. And so, yeah, I'm like, let me show you guys a little love. Let me show you a little love right about now. Thank you for coming and being here and showing your support to Survivor Speaks. I love you all. Love y'all. Let me give you a little love today. Just give you a little love today. Give you a little more and give you a little more. Give you a little more of what you came here for. Hey, bars. Not. All right. So, I see a little train wreck about to happen, and it's not about to happen because I got something to do. Oh, wait a minute. Maybe not. Maybe it's just me. Let's go on here and let's try this thing. But if it upsets me, for any reason, I'm gonna be a little PO'd. And I don't think they want to see me a little PO'd. So we're going to get on into this YNW Melly case. Like I said, I'm going to show him walking in the courtroom. Then I'm going to skip to the end where the meat is. I don't want to be here long. You don't want to be here long. And we don't want to be here long. So let's go. So there is YNW Melly for the first time. You know, we haven't seen him in a little while, but here he is talking to his attorney. There was
8:30 regarding the defense motion for hearing to determine potential conflict. So, whenever you're ready, Nicholas.
Thank you, Your Honor. Rutledge and other cases, federal cases, because state court really hasn't delved into this area as much as the federal case law does, indicates that there are certain things we need to find out first of all. So I don't know if this is the hearing or you want to set a hearing, but the bottom line of it is that the first thing we need to know whether Miss Liberty is still under investigation. We were told before the hearing by the state, I have no reason to doubt their word, that she still is under investigation. So that raises for us a number of problems. It may look on the surface that the only thing is, does Miss Liberty need to get permission from Mr. Devins to stay on the case and for him to waive conflict, but it's much deeper than that. And the reason why it's much deeper than that is we don't know what the state has subpoenaed. We do not know what they have in their possession. We do not know, other than the Apple accounts, if they subpoenaed other things. Therefore, we do not know whether communications that we have had with Miss Liberty have been intercepted, and therefore, we've been told that nobody else on the defense team is under investigation, but there are certainly confidential communications that we would have had with Miss Liberty. There are communications about trial strategy that we would have had with Miss Liberty that we do not know who is in possession of them, what is going on with them. Now, the case law seems to be pretty clear that during this type of process with an attorney who's on a case, that the state is bound to return innocent or innocuous or confidential communications to Miss Liberty. But she has not received any. In fact, she didn't know there were any that were to be received until the date that's mentioned in the motion. So where does that put us? As I said, we've been told that the defense team other than Miss Liberty is not under investigation. But we do know that there's an ongoing investigation. What we have now been working for nearly a year or over a year with the state being in possession of documents dealing with Miss Liberty. If in fact Miss Liberty has to get off the case because of the conflict that she would have, this is a year too late. We should have been informed of this a year ago. So the defense team and Miss Liberty, and therefore Mr. Devins, for a year are working on this case with the state knowing that there's the potential that Miss Liberty will be indicted or an information filed against her in the exact same case of tampering with evidence and with witnesses. And if that becomes the case,
and that is a very dirty tactic to use his attorney I'm so bothered by this, you know, because if his one of his attorneys is under investigation, the state knows about it. They are the one that they are the ones conducting that investigation. That definitely may or may not hurt Mr. Demons' case. However, it also doesn't look well for the defense in my eyes. Now, should they have brought this up now? No, they shouldn't have. should the state have advised them that Miss Liberty was under investigation? They sure should have. So, Melly could have made a decision after consulting with his attorneys. And like this gentleman said, and like I told you in my opening, Apple is the reason why they know that there is an investigation against Miss Liberty. If it wasn't for Apple, they wouldn't know, and the state would be still standing just like she's standing there like, what he talking about? I don't have a clue as to what he talking about, or at a screw what he talking about, however you want to perceive it. But they would be still standing there like that. In some cases, could Melly be found guilty and this overturned on the appeal? I feel the same way I feel in the YSL trial. Bring the evidence, bring the case. Let the jury decide whether or not he is guilty or innocent, or unless, some people opt to have like a panel of judges to determine whether they're innocent or guilty and to determine their sentence. Some people opt for a 6-man jury. Some people opt for the 12-person jury. And whatever they opt for is definitely has to be discussed, because it is ultimately Melly's decision. I just think that this is a play. It's a bad one. Melly and Miss Liberty, I think he looks at her like a mother figure. And you can look throughout the cases, any case, and you will see, especially those cases that linger on for as long as this one does, that, the attorneys get quite familiar and they see their client on a whole different level. So, no one can actually downplay or assume what their relationship is about when they are conversing, whispering to each other. He may just be telling her, like, what he had such a bad day, or things that happened to him that he can't say. Because according to them, they have even, when she comes to visit him, they make them visit between a glass. And so they have to talk on the phones. Those phones are recorded as well. Just because it just seems like you're going on a visit and you're talking to this person, those calls are recorded. She is his attorney. That is a client attorney privilege. Nobody should be able to hear what they spoke about while she was there visiting him. If you're going to do that, then if the investigation has anything to do with Melly's case, you need to make that known. You can't just be holding on to information like that because you feel like it, or because you don't think that you should. So this attorney the judge is going to ask her a serious question once the defense finally gets through to him and tells him. This has been going on for a year. They've been investigating her. They have not said anything. If it was not for Apple, had it not been for Apple on our side, we wouldn't have never known that she even had an investigation that has been lodged against her.
Oh shit! Oh shit! Oh shit!
So, in that case, you guys may need to let us know, or we need to see the subpoena, something, in order for Melly to make the correct decision. And it's only right. It doesn't have anything to do with anything else. Like I said, I don't have a dog in this fight, either way or another. Defense or prosecution. Don't know none of them. Don't know Melly. Don't know his family. Don't know none of those people. But right is right and wrong is wrong. And this is wrong on all different levels, because this is a play. And if you're somebody that I'm going to go to a couple of channels, because I've been kind of like busy the last couple of days, to view what some of these attorneys I have to say, hopefully, this is not an investigation that is the fault of Miss Liberty and Melly. Hopefully that's not the case. Or they could have even just waited till after this case was over and brought those charges against Miss Liberty. They have, the room to do whatever it is that they want to do. This is their case, prosecution's case. You could have waited. This is a play. Let's get into it. Let's get right back into it.
She obviously, whether there's a conflict or not, that has been waived up until that time. I think the case law is pretty clear. At that time, if she has charges against her, she has to bail out. In fact, I believe, and I'm not sure because it's federal case law, but I'd like to read to the court this paragraph from the case of U.S. versus Shagan, 661 Fed Sup 1289, 2009. In contrast to McLean, where the defense counsel was under investigation for a crime unrelated to charges against the defendant. Here, defense counsel would have been under investigation for crimes that threatened the integrity and fairness of the trial. Were the government to inform the court at the eve of trial or during the course of trial that the defense team was under investigation for witness tampering, under the principles of McLean and as conceded by Cronin, the defense team would be forced to withdraw its representation of Dr. Shagan. In fact, David Marcus made the motion orally as soon as he heard about the investigation. Such a development would have deprived the defendant of a defense team that had been intimately familiar with his defense, causing him severe prejudice. And that's where we're traveling down right now. Even if we stay on the case right now, if charges are brought against Miss Liberty, and they happen to fall before the end of Mr. Deming's trial, we may be forced to, under the law, to withdraw as an entire defense team. But a question still needs to be asked. Why did the state wait, not to tell us, because they never told us, we had to find it out through Apple, that there was an investigation? Because a year ago, we would have sat with Mr. Demings and I said, you know what, I need a new defense team. And we would have been off the case. But for a year, basically, we've been on a case that maybe we should not have been. There are things that we need to know. We need to know who reviewed the warrant, who signed the warrant for the state as far as authorizing it. We need to know whether there was a tainting. If all this information was gathered and given to the state attorneys that are prosecuting this case right now, there are innocent, innocuous, and confidential communications that will be in the hands of the state. That is improper. A tainting should have been set up that reviews the documents and makes sure only those that are specific to the search warrant are looked at by the trial team. Questions need to be asked. If in fact Ms. Liberty is under investigation, then why were the subpoenas sent out and why did that investigation begin now? And what I mean by that is, there's a statute of limitations. The state was under no obligation to begin that investigation until Mr. Demings' case is over. Therefore, there is no perceived conflict.
I haven't been able to take my eyes off my husband's pants since he tried this morning trip. What happened afterward was unbelievable.
I thought it would be just another quickie.
There is no conflict because we don't know that they're thinking about investigating Ms. Liberty. But instead, we were not put in that position to know that, and a year went by. If they had waited to the conclusion of Mr. Demings' case, as I said, then there is no conflict. So the only thing that I get from this is that there's the chance that within the next whatever year, or 10 months until the trial date, 9 months, whatever it is exactly, that Ms. Liberty is in fact facing charges formally. And if that occurs, then A, she can't try the case. I'm not sure the rest of the defense team can try the case. And don't know, and prejudice to Mr. Demings would be monumental that at this late stage you have to get a whole new defense team. So we need these questions answered. It's not just a simple, is there an ongoing investigation? We need to know the extent of it. We need to know the whys of when it was instituted and why why didn't the state wait for this matter to be over? We need to know whether the state, if they're going to charge Ms. Liberty with this crime of tampering, do they intend to try her at the same time as Mr. Demings or a separate trial? Obviously at the same time it even raises more of a conflict. We have a question, and that scares us. Ms. Liberty has not been allowed to see Mr. Demings in person for the last, before I got on the case, for at least the last year and a half. When she goes to the jail, she must pick up the phone and use one of those phones to talk to Mr. Demings on the other side. Nobody will ask for an issue by phone. Have they been tapped? Have they been listened to? We need to know what communications, what has gone on. So it's not just as simple as, is there an open investigation? Now, as far as going forward on these other motions that you said, we can't go forward as a defense team on any of these motions until we talk to Mr. Demings and have him understand what's going on. And for him, first of all, to make the decision. Yes, I want to keep this defense team. Yes, I want to keep Ms. Liberty. or no, I need a new defense team. We can't do anything until that's decided. I will say that after doing the research that I did over the weekend and came up with the case I cited to the court, I think all members of our defense team need to call up the Florida Bar and to see whether we're obligated, now that we know that she's under investigation, that we're obligated or not to withdraw from the case, regardless of Mr. Dennis's disposition. So that's where we stand today. With all apologies to the court, though, I do not believe we can go forward with these motions. Mr. Dennis has a lot of thinking to do. Hopefully the court will give us a hearing and some of these questions are answered, and then he can make a logical and an informed decision. And by that time, we can find from the bar whether we have obligations regardless of this decision.
So he just said something that was very important. They don't know whether the charges that the state is bringing against Ms. Liberty is going to force all of them to be removed from the case. So being that this judge is adamant, he is starting this trial in September. That will not leave the new legal team, leave them much time to deal with such a big case. This is a capital case. This man's life is on the line. And so with that being said, everything that they need to do so that whatever decision will not be overturned if he is found guilty, everything that would prevent that needs to happen. Once again, the last prosecutor that prosecuted the first case was thrown off of this case. Is she still a prosecutor? Because the last judge sure enough threw her out. You were doing all sorts of stuff that you shouldn't be doing. All that. Your gang experts is just as bad as the gang experts in YSL. He did a lot of Google searching and all of that. Came in to testify in a black ski mask. Is this a stick up or is this a courtroom? And so one of the jurors, when they tried this case the first time, she got scared. She said, should I be wearing a mask? If he is here on behalf of the state and he's wearing a mask, should I be wearing a mask? This is something that I never ever thought that I would say out of the top and the bottom lip and the tongue that's in my mouth. When it comes to that, and you know that's bad when Fulton County got one up on you. Fulton County, I don't want to be on camera. If the judge granted it, okay, well, we're still going to record the proceedings. We just won't show you on camera. They didn't walk in there in no daggone ski mask. Even though it felt like a stick up, hey, like a stick up. It felt like a sticker, but this guy was straight on the stick. I'm talking about he had one of those wool caps with the eyes cut out and the lips, and that's it. What professional is going to wear that on the stand anyway? So all the Googling that he did, right, to bring this information that anybody can look up, I don't think it's just not the type of gang training that I had. It's just not, this is Google friendly information that you have. And of course you can't get in the court of law and tell them exactly what it is that, but no, if you can't explain certain things where you got it from, and stuff you are explaining is wrong and incorrect, that's because where did you get your gang training from? We found out where they got their gang training from in the YSL trial. Each other. And none of them could tell the truth if the truth jumped up on the stand and was going to be their mouthpiece. I'm just
Oh shit! Oh shit!
I'm just saying. All right, so we're gonna go on ahead and get on over, get back to this court hearing, and I'll have some more commentary if they say something that I want to speak on.
Rutledge says I have to find out if there's an investigation, and it says there is. What is your authority for all those other things that you said you want to answer? Because I didn't find any authority. I don't even know how I would do that. Well, do you have any authority? I understand you're saying that's this is what we like. I read what Rutledge says. That's what I'm doing right now. But you want to know about investigations. You want to know about a judge who reviewed a warrant. How would you suggest I do that? And more importantly, do you have any authority that supports any of those questions?
Well, the authority that I have, Your Honor, is the Sixth Amendment to the United States Constitution, which requires me and which allows my client to have competent counsel. And without being able to go into these things, and I also rely on the 14th Amendment due process, without being able to go into these things and have a hearing where all these things are ferreted out.
A hearing, that's what I'm asking. What do you, I don't want you to confuse some type of hearing defending this liberty. That's not really the issue. That's a yes or no question, the Shaner investigation. The answer is yes. So the only other question that Rutledge requires is that Mr. Demons has to decide, does he want to go forward with her, or does he want conflict-free counsel, which I think he's certainly entitled to. And if he wants to apply that to all of his lawyers, he may do that. But that's a discussion between you and your client. I can't intervene. You're asking me to do fact-finding on behalf of your client so your client can make an informed decision.
Well, then I will file another motion for prosecutorial misconduct and ask for a hearing on that. Subpoena witnesses in. The state will move to quash the witnesses that I will be calling in, and we'll have hearings going down that path. But this is something, no offense to this court, but I do not know how this court says that's the only thing that matters to me. There's a whole laundry list that deal with not only conflict.
That's what I'm asking. Do you have any case law that tells me I have to do that? I'm happy to do that. You cited Rutledge, and I read Rutledge. Rutledge doesn't
I
say
have no
anything.
case law in front of me right now that says you have to do that. But I would think it would be the inherent authority of this court that you should do that. And there's certainly nothing that says you can't do that.
That's usually that podium that talks to me about my inherent authority, which I don't exercise. I'm happy to do whatever a statute, case law, or criminal procedure tells me to do. I don't make up things on my own.
Then I ask the court, let's go one step at a time. Right now, Mr. Demons now has been informed that his liberty is under investigation, and let us see what he decides. If he doesn't want us on the case anymore because of this, then all the things I've raised will be raised by another set of counsel. But if he does, we will be filing other motions in order so that we can get these questions answered, because Mr. Demons needs to know these before, quite candidly, he can make that choice. He can say right now that he wants this liberty, but after these facts come out, depending on what those facts are, he may decide he doesn't want this liberty or the rest of the defense team. So we'll take it one step at a time.
So your request is you want me to hear any of these today? And
I don't think we can.
when would you like me to reset?
I do not know how long it will take. Miss Liberty is not in town yet right now. She's on a plane. She got snowed in Montana yesterday. Drove from Montana to Seattle. She was on an airplane ready to come here, and they canceled the flight while she was on the tarmac. She got another flight, including Phoenix. She's now on a plane from Phoenix to here. Almost all these motions that you went through are Miss Liberty's motions. So A, for logistical purposes, we can't hear those motions this morning at least. We're hoping that she's back at 1:30. But I do think it takes some time for us to talk to Mr. Demons. She certainly needs to talk to Mr. Demons. So, you want to reset it for, I don't know if we can speak to him tonight sufficiently or not. You want to put it on for possible motions tomorrow with status tomorrow? You can, but I'm not sure that's enough time to talk to him.
It's not enough time for any candidate. And we need to develop, if I may,
Yes, sir.
we need to file, based upon your Honor's comments, we need to file a motion requesting certain things about this investigation concerning the paint team, whether or not they relayed any of that information to the prosecutors or the investigators in this case. And I want the court to know, they didn't tell us. Apple informed Miss Liberty that a search warrant was issued on her Apple account back on December 13, 2023. As a result of that, I contacted the Broward Sheriff's Office and spoke to Christian Sabonis. And I sent him a text message that said, I was just advised that Broward Sheriff's Office issued a search warrant on Miss Liberty's Apple account on December 13, 2023, over 1 year ago. I would like to discuss this with you. He responded by saying, hi Stu, I have zero knowledge of this search warrant or its application. Your email is the first I have learned. First, I would defer to whoever the affiant was. I don't have access to that information. I in turn contacted the state, and they said they would get back to me, which I spoke for the first time this morning to the state concerning this. I think we need to know the procedure of the so-called paint team so that any privileged communications were not relayed to the prosecution team and or its investigators. We also need to know why, since Miss Liberty represents numerous other clients, whether or not they have severed or separated those privileged communications that have nothing to do with their so-called investigation. We need to find this out.
Well, do you even know the investigation has to do with this representation? That's exactly what I was just thinking, what you just said.
I assume it is since it's issued from the Broward Sheriff's Office.
How do you know it isn't related to one of our other clients, one of our other cases?
Well,
has
that's all
anyone
I had.
said anything that this has anything to do with Mr. Demons?
I can't answer that without seeing the search warrant.
We're not here to make work. Does this have to do with Mr. Demons?
It doesn't.
Okay.
So, can you give them a copy of the search warrant?
No, because it's a pending investigation that's still ongoing.
how does Mr. Demons make a decision about whether he wants to waive any potential conflict or not without having that information?
The only thing I can say, Your Honor, is again, it's a pending investigation. Knowing that she's under investigation is what all that she talks about. You can't give anything over until it's officially completed.
With all due respect, Ms. Bucko, this is not a due process part when the state's seeking the death penalty. The state's seeking the death penalty. So you need to turn over the affidavit and the search warrant so the lawyers can make an informed decision. All right?
It does not have to do with the homicide case.
Well, he needs to know if there is a potential conflict of interest. He's either going to make an informed, intelligent waiver of that, or she will no longer be his lawyer. And then he has to make the same decision for all of his other lawyers. And he is going to trial September the 10th, 2025. So we need to do this now. So how long will it take for you to get a copy of the affidavit and a copy of the search warrant and give it to opposing counsel?
I'll speak in my office, and if you can have a week to figure this out.
Judge, they've had since December of 23. They didn't even have the courtesy to inform us of a pending investigation. We had to learn this from Apple.
But you're telling me it relates to this case.
To the tampering case.
So why would this be different than any other search warrant in any other criminal case? The defense counsel would be entitled to it.
Because she's not a subject that's been charged yet, potentially could be. It's pending investigation. All I can say is, again, pending investigation, there is a taint team in place, and it's still pending. So it's not like we have to handle a discovery of her. She's not implicitly defendant yet.
No, but let me repeat myself. Mr. Demons has to make an informed decision about who he wants his lawyers to be. He's now been sitting in our jail for 2,159 days. So how long would you like to make that decision?
The investigation will be over. That's up to the Broward Sheriff's Office, but I can, as I said, I'm just asking for a week to determine whether or not we file any sort of motion to prevent the search warrant from being handed over.
And I just can't imagine any legal grounds for that would not happen in this particular case.
So I'm confused. So if she's under investigation for this case, how do you think you're going to withhold a subpoena for her phone records? They need to know whether or not they can go forward with this case. It could be my opinion. I think they want all of them off of the case and hoping that he doesn't get any competent attorneys. So I just don't understand how she's standing there like it don't matter, and it doesn't matter to her. But it does matter to Mr. Demons, and it does matter to his attorneys. So if this one attorney can be excused and he doesn't want her to represent him anymore based on the information that you're investigating her for, he has to have some type of knowledge. Why would he just say, okay, yeah, I'm investigating her, so she's off the case? That's not how this works. This is like an ambush. This is like it's like an ambush. Like, okay, we got this. We're investigating you. We weren't going to tell you. We are kind of upset that Apple even sent. Let me tell you something. Apple was not agreeing with the courts at one time. There was a time where Apple would not turn over anybody's records. And I don't remember when that changed, but I know they was having a hard time trying to obtain Apple records. They can get all of the records they wanted from every other phone company. Apple was like, nope. We don't care what you're doing over there at, so-and-so and this and we don't care about that. You're not getting any of these records. But he has a right. This is a capital case. This young man can lose his life because of this case. So I don't see how they think that they were going to keep this from him. Just my thoughts, but let's get going and get back to the video.
Is it death penalty?
I understand that. And then I'm asking for at least a day or two.
We'll decide by tomorrow. I've also reserved all of it tomorrow. I took over Division FT. Judge Murphy had 44 pending first-degree murder cases. I've set them all to trial. I'm booked to trial through July of 2026. So you all think I have 2 entire days at some point in the next 18 months to do these again. I do not. So
Understood.
I'm not sure what it is you want me to do. You don't want me to do anything else today.
We can't under the Florida bar rules.
So do you want me to leave them on for tomorrow? You will have the balance of today to discuss all these issues with Mr. Demons. And state you will have the balance of today to discuss some reason why you can't just turn over this affidavit and search warrant? I mean, it may be something innocuous. By the way, for the record, I don't know anything about this. No one brought me a search warrant, so. But maybe it's something so de minimis that Mr. Devins is going to say that's fine. If there's any conflict, I'll waive it, and let's get to work. Or if not, I guess he's going to have to go find 5 other lawyers to do this who are have to be ready to try a capital case in 9 months. So, how about tomorrow at 9:30?
We'll be here.
Stay tomorrow at 9:30.
That's fine, Judge.
It can't give us, I'm not picking on, but the answer can't be, my office told me XYZ. Someone better be standing here with some authority that tells me what we can do. Okay?
Just one other thing.
Yes, sir.
You mentioned about the trial schedule, and we're obviously going to try to do it. I just want to let you know, the matters that were appealed are still up in front of the court DCA. The state, I believe, just filed the last document in the case, so there may be one more that they need to file, one more reply brief. I would suspect that it's going to be set down for oral argument, and then I don't know when we can get a ruling. The problem is, the stay that was issued by your previous judge, we cannot go into anything on any type of discovery as far as depositions, as far as motions, as far as anything dealing with the matters that are up on appeal. So when that all comes back, we will be rushed to get everything else done. Just want to let the court know, we're under the mercy of the fourth.
Is there anything pending at the 4th DCA regarding the tampering?
Yes, everything that was on the homicide is also on appeal to the tampering because it's the same evidence.
Yep.
And Judge Murphy entered an order.
Entered an order that says you can't do depositions?
We can do depositions on things that aren't on appeal. So we have been doing depositions on things that aren't on appeal.
For example, you did not read, unless I missed it, but there's a motion in which I'm asking the court to make the state tell us what of the 2 million or whatever amount of Instagram messages they intend to use at trial. That was filed a long time ago. We can't have that hearing because the Instagram messages, the whole thing is up on appeal. So we can't even go into that motion. Those are some of the things that await you.
Well, can I give you rulings on all those, depending on what, if I rule some messages are in and some messages are out, for example, and the 4th DCA says they're all out, then they're all out.
Judge, I wanted to move this case. I'm just.
Do you have any objection to doing that?
We're not going to file this day.
Do you all have an objection to doing that?
Well, I think I'm confused on the motion that you're bringing up because all of the Instagram, if I remember correctly, I have to look, is up on appeal.
Right.
So, I mean, it would kind of a waste of time to do the motion.
Oh, no, a waste of time is reserving 2 entire court days and doing nothing. That's a waste of time. So do you have any objection to going forward and hearing and ruling on any and everything that's pending?
I think that we should start with the things that don't affect the appeal, and then, because there's plenty of those to be heard, and then we can go forward potentially with the other ones.
And I'll be candid, I did not think we were hearing the Instagram matter whatsoever. So I'm not looking at that motion.
Okay, so why don't we do it this way, all right? He's going to remain on the docket tomorrow. I have a few other matters on both FX and FT, so let's call it 9:30 tomorrow. And defense, you can come in and tell me you get a chance to talk to your client, because he's going to waive any potential conflict, and I guess it doesn't matter.
Yes, it does, Your Honor, because he'd be waiving the conflict without knowing what's in the search warrant affidavit.
Correct.
So therefore it would be an invalid waiver because he's not totally informed of the facts.
Okay, you're going to tell me what you want to do, state. Maybe you can identify the motions that you think we can go forward. I mean,
We sort of addressed it in the motion to strike notice because we've been asking since our hearing in October to know what motions are going forward the next 2 days. Couldn't get an answer. We've asked in depositions from Ms. Liberty, couldn't get an answer. We emailed, we couldn't get an answer. And then just a few days ago, we got a notice of hearing. Half those motions aren't even filed within the court file in Odyssey. So we identified, I think, 4 that we are ready to go on, that we filed responses on. There's no motion filed for some of these.
we're going to trial in September. I mean, I'm not prejudging things.
I hope so, Judge.
No, I can absolutely guarantee you. He's going to go to trial in September. So I'm going to do everything that I can. If I have to rule on things during trial, which is an awful way to do things, because I know you both know, but if that's what it comes to, then that's what we're going to do. So
Assuming we're still on the case. And that's a big assumption at this moment.
And just they're still asking for proper notice of what we're actually going to hear.
I'll take the blame for that. All pending motions. That's why I put that down to the name. All pending motions. They're asking for I believe they're asking for a Daubert hearing on cell phone records. They're asking for a Daubert hearing on some other matter, cell phone mapping. There's a whole bunch of things.
Some of those have already been ruled on, Your Honor. The ones that they've noticed, I think, and again, Ms. Liberty admitted to this last time we were here in front of Your Honor, that she filed things with the wrong case number, wrong title, she's going to fix that. None of it has been fixed. So the state is entitled to proper notice so that we can respond accordingly.
We'll see you tomorrow morning. Fair enough?
Okay, I'll see you at 9:30 tomorrow. Ms. Wilcox, does that otherwise conclude FX and FT for today?
Yeah.
Okay, so the FX and FT will otherwise be recessed until tomorrow, which is?
Excuse me.
Yes, sir.
I've been told that Mr. Devins has federal court tomorrow morning on his civil hearing. Does corrections have any idea of that?
Not tomorrow, sir.
Huh?
It's not tomorrow.
It's not tomorrow?
I believe it's January 17th.
17th. Forget what I just said. Thank you. We don't represent him on that.
Tomorrow is Tuesday, January the 7th. FX and FT, we're going to meet this till then at 8:45 a.m. We'll be able to do it the rest of the evening. All right, Mr. Court Reporter, that is it.
Here.
No, the jail.
May we be excused?
Yeah, we're fine. Have a good morning. Use your time wisely.
Yes, sir.
So there we go. There is the hearing. I'm glad to see him smiling at, and I know that he's smiling at his mother. She comes to every one of his hearings to make sure that he knows that he still has support. I just want them to try this case legally and the way that they should try this case without any underhanded tactics. We saw when this case played out the last time that it was an absolute mess. And I don't think, because he's incarcerated, that he should be treated unfairly. But for the people in the back, for all the people in the back, whew, let me tell you, because I don't need none of y'all getting out here saying what Survivor Speak said. That's all the minute. Here I go. I heard y'all was looking for me. Here I go. Hey, here I go. Oh, anyway, y'all just seen some screens come up. So, anyway, for the people in the back, I'm not saying that he's not guilty. I'm a virtual juror, but I'm not deliberating over this case. I'm a virtual juror looking at the facts, weighing the evidence that was shown in the first case, since I consumed, and what's going on now. I don't know if you guys know, but whenever you go to a jail to visit someone and you guys are sitting on the phone talking between a plexiglass, those phone calls are recorded too. So if for a year and a half they have not been allowing one of his attorneys to come in to see him, and they've been making them have these visits, their visits via a plexiglass and on the phone, that is going to be a major problem. Those calls are recorded. That is attorney-client privilege that they have no right or access to. It does, like the attorney argued, give the state a leg up on what tactics they're using, what they have, if they have new evidence to show, meaning that this is a new trial or what have you. We see that the prosecution is working up to the very end. Like I said, I think that this was a play on regarding the prosecution, and I don't think that it was a good play at all. I don't think that it's funny. They should not be using this as an experimental piece. And this is why they need to start holding some of these prosecutors accountable. You want to behave in criminal activity, then you need to be treated as a criminal. You need to be treated just, as a defendant. This man has family. He has loved ones too. My heart goes out to the two young men that lost their lives. My heart truly goes out to them. But if the state keeps playing these games, and this young man did commit those crimes, you guys are not going to see any justice. They're doing all types of stuff in court, outside of court, messing with his rights, starving him, not allowing him to use the phone. Now that is a big one and a big no-no. Because the only reason why you would be not allowing him to use the phone is so that he can't get in touch with his family. It's like so he could feel like a sort of rejection of some sort. And some people would even say he would go as far as, unaliving himself with the tactics that you guys are playing with him behind the wall. And I'm sure this coming from somebody that's in the courtroom, not the judge. This judge is new on this case. But the courtroom and the jail is two separate entities. They're not supposed to have anything to do with what the security in the jail. They won't even come into a court of law and testify about the security measures that they take and use inside of a jail facility. They won't do it. Everybody would be in trouble. Everybody's life would be in danger. And so that's not something that they would come out and share with the public. Or if the judge really had a question about something that Mr. Deming's attorneys presented, and it relates to security in the jail, the judge can, bring them in his chambers. And you see how Mr. Demings is privy to be at everything that's scheduled in regards to him. He will not be able to go into that meeting because it would jeopardize the security of the facility. That's about the only thing that they are allowed by law, and they would get away with withholding from him, is if it has to do with security. And endangering the lives of the people that are taking care of him and making sure that he remains alive, or I'm not, too sure about that. Because, yeah, they've been doing a lot.
Oh shit!
Yeah,
Oh, shit.
we get the reports. And so that's it for me. I will come back with part 2 of this video at a later time. Right now, I just wanted to go over part 1. This is quite an interesting case because of what transpired during the first case, and because it's so intriguing that they have this man on trial for unaliving his 2 best friends. And who wants to think that? Who wants to believe that? But if that's what the facts and the evidence says, then the court has to do what they have to do, if that's what the facts and the evidence says. And so they just need to bring the evidence and the facts and let the jurors do their thing. Let the jurors do their job. But it's when you start throwing all the extra stuff. When you start throwing in, we're going to make sure he doesn't walk. So when we start fabricating evidence and stuff and putting it up, out there as facts, and then you get caught like a deer in the headlights, then that's when we have a problem. Round of applause. Round of applause for the, I believe she's a detective. I don't have her name right now, but a round of applause for her, not for her saying, I'm not going to do what you want me to do. I'm not going to jeopardize my job and break the law because you want me to break the law. There are certain things that I have to report, and I need to report what I saw. And what I saw was, and this is not what she said verbatim, this is me paraphrasing. Okay? I want to let y'all know that. Also, in the back. So before you open your mouth, you can shut the fuck up. So, what she said was that, they were not talking, they were talking like so nasty about Mr. Demings. It was unprofessional, and she did not join in. They did not do some things that they were supposed to do, and she got on the stand. They called her into the courtroom, and she told it, which caused the prosecution to get her behind thrown out of there because they put her on the stand, and she got on the stand and told a bunch of untruths.
Oh shit! Oh shit! Oh shit!
So the judge told her, pack your bags. You ain't got to go home, but you got to get the freak out of here. And off she went into the sunset. But I'm going to end this show because I got something to do. I'm going to end the show like I end all of my other shows to make sure that I tell the men that you can get breast cancer. We understand the stigma of the word breast. So here, Survivor Speaks has changed the name to chest and or peck cancer. Peck cancer, if that makes you feel any better. But I'm just here to tell you the truth so you don't believe any myths that are out there running about. Men get breast cancer too. If you're feeling anything unusual in that area, make sure you get tested. Make sure you tell your doctors to test you for breast cancer. You may have to initiate that on your own because, like I said, breast, men, it just does not, for some reason, resonate with some people. But to all my ladies out there, make sure you ladies are getting your mammograms. If you're old enough, if you are a breast cancer patient, there are laws where if you have a child that's a girl, there's a bunch of laws out there that, they have to abide by as it relates to being of age and getting a mammogram. So make sure you get your mammograms, feel your boobies to make sure that you are all right. And don't you dare let anybody come into your house and disturb the peace that passes all understanding. I am Survivor Speaks, and I will see you guys out here in these YouTube streets, maybe. Sometime I'm on Twitter. I travel over to Instagram every now and again, but I don't stay long. I just go out. I be checking out some things. I got specific things to check. So, if you leave me a message and it says I'm on green, I don't know if the thing said that you on green because, the phone, we don't close the app. We don't want to keep pressing in our password half the time. Hell, we don't even know what the password is. And so I may not answer at the time, but when I see it, I will answer. I'm well aware that when you go into a message on Instagram and you look at the message, it said that you seen it. It said that you saw it. It said that it don't say you read it, but it does say that you seen it. And that's okay. But a lot of times, I'm not on the gram like that. I'm not on the gram like that. I don't have time. So I'll go over there when I do have time. So I will be checking you guys out in the next live stream or the next video. See you guys later. Peace.
Full cycle, I just might though just like a Michael. Mama gone now, I'm thinking death is not we entitled. And it was me versus me, them battles had to fight through. And when you way in the dark, them demons try to fight you. But you can't let them when you gotta see the damn light. Diabetes came from nowhere, messed up whole life. That's what I used to think, my mama helped me out. I got one deer in this guy to make proud, don't count me out. Let's get it started, rest in peace my mama, I don't wanna talk. Fresh fit, who that little nigga, fresh the way he walk. New drip, I'm that one dude creating all the sauce. News flip, you that one do the worker, not a boss. It's safe to say that after all this, I'm standing tall. It's safe to say that after all this, I'm still gon' ball. It's safe to say that after all this, I never fall. I never